Welcome back to another episode of Office Hours with Professor Brad Perkins. Today we have an encore presentation from Baker Group. I had a contractor show up and bring his attorney with him. Now, normally as an engineer, I'd be a little bit afraid of that particular meeting, but being as we just finished our engineering law class, and it seems pertinent to the discussion for this and maybe other engineering law classes in the future, I'll definitely be referencing our particular discussion here today. With that in mind, I'd like our guests here in the studio to go ahead and introduce themselves, if you would, sir.
Sure. My name is Blake Scott. I'm in-house counsel with Baker Group right now.
All right, in-house counsel. All right, you can't just say that without.
Nope.
I need an explanation. Remember, we're going for students. In-house counsel means?
It means I'm an attorney, and I have one client, and my client is Baker Group. And I'm not housed in a firm that you would normally think of as a law firm. I don't work for the government. I work for one corporate entity. And all of my, they're called constituents, people within the company can come to me for advice that I direct for company purposes, not for individual purposes. So when I say in-house, that just means in lawyer terms, I'm inside a corporation or a company.
So you already have designated people whose interest you have to defend.
Yeah.
Okay.
Just as an attorney, the whole idea is you have a client, and your job, your ethical duty, is to give them sound advice, argue on their behalf, and be adversarial. And I don't mean that we're fighting all the time, but I am protecting one set of interests. So that's what I mean. Yeah.
Okay. All right. And then with him, we have Dale Drent with Baker Group, who is back here for another episode. But really quickly, Dale, you want to introduce yourself again?
Dale Drent, Vice President of our service group, also a mechanical engineer. I'll tag on to what Blake has said. Having Blake's been in-house for less than a year.
Year and a half?
Year and a half?
Yeah.
Okay. Year and a half. It's really refreshing to have him in-house.
Dale's sweatshirt is over a year and a half old. You know what I'm saying?
Time gets a little fuzzy.
Yeah. Dale's shoes are probably older than the students next to him. All right, you want to introduce yourself, please? Here, go ahead and swing in there.
Yes, I am Austin Deeb. I am a student in Brad's 241-251 class.
All right, so for perspective, right, first I'm going to say it's not the first construction engineering class, but it is, just getting into the heart of group work and projects and understanding, the different roles of owner, architect, contractor, subcontractors, that type of stuff. So very, very early. Have you had an internship yet? Like a real construction one?
Yes, I have. I was with the city of Cedar Rapids last summer. It was technically a civil internship, but I was out on roadway projects. It'd be kind of similar to what a Connie heavy highway discipline would be.
Okay, well, we need to fix that, right? Obviously, we can do better. It's all right, because I am the nemesis of the heavy highway types, and that's just my role. Okay, all right.
Don't ask me any questions about horizontal work. I haven't touched it.
I won't.
Good.
I won't.
Yeah.
I absolutely won't ask you any questions about that.
Perfect.
Now, could you give us? So, anybody that's watched our podcast before, Dale and I, we had a whole discussion of getting into construction engineering, getting into the mechanical emphasis area. Mm-hmm. Now, you were a Connie. No. All right.
I'm probably the most unlikely attorney to be sitting in this seat, to be honest with you.
How so? Okay, so how did you end up? I guess there's a question. How did you end up working for a contractor as in-house, counsel?
Yeah. So you've heard of the concept of value engineering?
Yes, I have.
So
I have. Someone value engineered you?
Yeah, the position has been VE'd.
Okay. What, they fired someone more expensive and brought you in?
No. Okay, so the whole story
okay.
is that I'm from Central Iowa, and I went to my undergrad at Central College in Pella.
Okay.
And I always knew I wanted to do law, and I took business classes. I always knew I wanted to do business law. And then I went to Drake Law. I was there from 2008 to 2011. And some of you may be old enough to remember 2008, 9.
Sure do.
was,
Actually, yeah.
Yeah, I do.
Is it-
Yeah.
He's got
Yeah,
nothing.
these guys,
Yeah.
the
Okay.
students got nothing.
Okay,
It was
for the
like,
students listening,
Yes.
it was a terrible time economically,
yes, it was.
to put it in simple terms. And if you were what we would call a transactional attorney, somebody who just wanted to deal with contracts, work in business, attorneys were getting axed. And so it was
There's no
hard.
contracts. I mean, you got to have contracts to manage.
Business was down, and so
Business was down.
business attorneys were down, and the positions were far and few between. And I had job offers coming out of law school, but none in Iowa. And some of you students may know how this is when you're dating a girl that you eventually marry. I needed to stay here in town.
Oh,
And
yeah,
so,
yeah.
So one of those, who do
Yes.
who do you know? I'd met some guy. I was coaching soccer at the time in law school, and he was a partner in a law firm called Hickson and Brown, and one of those ambulance chasing types.
Okay, all right.
And
Must be a friend of yours. You can call him an ambulance chaser? Or
yeah,
is
well,
it
I
just-
call myself one because I went to work for him.
Oh, you went to work for him?
Yeah,
Oh,
yeah.
okay, all right.
When I was in law
You're
school, I
like-
started working for him, and,
Right.
and so he said, "Hey,
Oh, that explains it. Like on the way
Yeah.
over here, there was a siren and your head snaps around. You're
Yeah.
like, oh, wait, no.
Involuntary.
you,
just
you
involved-
thought somebody's hurt. I saw dollar signs.
Oh,
It
okay.
was no.
We're kidding. We're
Wait,
kidding.
I am kidding because there's a storm doctrine, and so if you fall during a storm, you're less likely to get a recovery.
Okay, so you're like, it doesn't really do any
Storm going
good to
on.
chase the ambulances
Now's
in
not
a blizzard.
Now is a bad time to chase the ambulance.
Okay, okay.
But-
all right.
But point is, I fell into that world, which was
Okay.
civil litigation. Was
Okay.
actually probably a better way to describe it. If you wanted to sue somebody, you wanted to sue a company, you wanted to sue any entity, we would do it. But our emphasis was on medical malpractice, professional liability, so legal malpractice, sue other attorneys, wrongful death cases, that sort of thing.
Isn't that pretty tough though? I mean, you just got me kind of fascinated here.
Yeah.
It's like how do you? Okay, for an engineer, malpractice.
Sure.
Something broke and people got hurt. I lost money. I lost time.
Yeah.
Right. There's obvious. Okay, you designed it and something bad happened. Therefore, there is liability.
Sure.
Right. Or for a contractor, you were supposed to build something. It didn't work. It fell in. Something broke. Okay. Right. How do you sue for legal I mean,
Yeah.
what's the? I mean, the whole point
Okay.
of every case is somebody wins and somebody loses. Just because you lose doesn't mean there's malpractice. How do you even prove that?
Wrong.
Okay, all right.
So-
Well, that's why we have the attorney here. Hold on. Let me just say, should you need actual legal advice, please do not consult a podcast for that.
Yes.
Right?
This
The,
is all generic.
The broadcaster here is not an attorney, nor does he play one, nor does he want to be one.
Hold on, include all of us in
Well,
that.
hey, I don't care about you. You're,
You gotta have your own.
you are an actual.
I need my own
attorney, right?
disclaimer.
Your own disclaimer.
Hey,
Let's
none of
make
this
another
is-
lap around. I'm not
Okay.
an attorney either.
This
Okay.
is not legal advice. I'm just generally speaking. But
Exactly, not
okay.
legal advice.
to answer your question,
Okay.
so you've heard the word tort.
Well, sure. Yeah,
Sure.
we in class we talked about torts. It's like okay, something happened. Somebody was injured in some way,
Right.
Either physically, financially, whatever,
Right.
and somebody else is responsible for it.
Sure.
Okay.
Now, so tort being an old Latin term, twisted, you're not on the straight and narrow.
Okay.
You eventually get to tort. That's the word. I don't
Okay.
have all the history in front of me. But the idea is that we all owe each other a duty of care, a duty of reasonable care to act in each other's interest for safety purposes. Property damage, personal injury, pecuniary to some extent. We all have that reasonable person standard. I can't
Mhm.
just go out and crash my car into you because I'm not paying attention. That's not reasonable behavior for somebody in society and is actionable in the legal sense. And we would just call it negligence, or it's a tort. I don't have a contract with somebody on the road, but if I run into them and I injure them, they can sue me. Okay, so now take it a step further. The professions, law, engineering, medical, with their licenses and their boards, society and the legislature has developed these, and they have a higher standard for safety of the public. So an engineer or an architect, okay, you have a standard of care that's applicable to you to design, buildings that are safe and don't injure people when they're on the premises. If you're a doctor, you also have a standard of care that it's difficult to identify, but with experts, you can. There are right and wrong things to do in medicine. If you're a lawyer, there are right and wrong things. There is a standard of reasonable care to your clients. If I just blow a deadline and your case gets tossed, you had an asset that you've now lost. That is a tort. That is, it could be breach of contract too, but it's most likely you have a malpractice suit against me. And so when I say that we did professional liability, that's what I'm talking about.
Okay.
Yeah. So, you've done a lot of expert work, and maybe you've probably talked about it in your construction law class about acting as an expert. Maybe
Yes. Yeah, we did. Yeah.
Testifying. What is the standard of care? What was reasonable for the engineer to do or not do, or the architect to do or not do in a given situation? Well, for 10 years, a lot of what I did was that same work, but just dealing with lawyers, hospitals, surgeons, and I guess the short answer is I didn't enjoy it.
Okay.
I did it.
Okay.
I never.
All right.
And it's one of those deals, and some of your students will find, this is a good piece of life advice here. I think you guys can correct me if I'm wrong, but the longer you do something and the better you get at it and the more money you make and the more entrenched you get, the harder it is to leave.
Oh, no, that's definitely true. That's definitely true.
So that's what happened to me. I needed a job. I took it, and I got better and better at it. But it got to the point where I'm married to a nurse. She flies.
Ooh, that'd be a little uncomfortable, right? Like
Yeah.
seeing all the doctors and then.
I have a lot of friends who are in the medical profession.
Mhm.
The thing about, I know this is a construction podcast, but
Right. Well,
but
that's okay.
it's
about-
similar to engineering in that the standard isn't perfect.
Oh yeah, no,
But-
we've literally discussed that exact thing.
Yeah.
Where the standard for perfection is not the standard, nor should it be the goal.
Right.
Now the goal should be working towards perfection, but
Sure.
perfection itself is not the standard.
Sure. And the same thing is true in medicine or anywhere else. But the people who are calling you and want you to represent them, they don't agree.
Yeah.
See,
Yeah.
And then they
Yeah.
want you to make good arguments why Dr. So-and-so breached the standard of care. And you kind of sometimes feel like you're stretching it. As lawyers, we're just kind of quarterbacking up the case. It's up to experts, but not to denigrate experts. You pay enough, you can find somebody to say most things.
No, I know, I know that is absolutely true, and
Yeah.
that's one of the things I liked about being an expert, but that's not my primary function or job.
Yeah.
And what's awesome about that is, so somebody comes to me, a lawyer comes to me and says, "Hey, I want you to be an expert witness on this," and I'd be like, "Okay, who's suing who? Why are they suing? Let me see the case."
Yeah.
And I could review it, and if I was like, "Nah, I don't think that's I don't agree with you," I can say no.
And those are the experts I would call back.
Right, but there are those out there, and I've ran into them like on the other side of the table, where they're just an opinion for hire. They'll say whatever it is you pay them to say.
Yeah.
And there's a lot of firms that's just what they do. They're experts for hire.
Mm-hmm.
That doesn't make them all. I'm not saying that all of those guys are that way, because there's some very good ones out there.
Right.
But I've definitely seen some where I was like, "You're a real engineer and you're saying that? I don't know." Okay, I'm sure they're paying you a lot to say.
Well, to bring this back to your original question, bring it on topic, I eventually got a little tired of what I was doing.
Okay.
And I just couldn't see myself doing it the rest of my life. And so I'd done it over a decade, and I started to look for other options.
Okay, well, there's a question that Dale and I have,
Yeah.
right? Because this came up. Remember, this subject came up when we did our last discussion. Did you get the talk from your wife? It was like, you need a different job. See, it's a talk. It's a real talk. Right? The student doesn't know what I'm talking about, and I'm wondering if you'd had it.
She knew. We both knew.
Okay.
Yeah, she let me know. Yeah,
Okay.
So I'm.
Yeah, he's a lawyer. Is like, yes.
Okay, so here's another thing about lawyers.
Yeah. They will say both yes.
It's
and
never black and white. It depends.
no. It depends.
It's so cold out today.
Yeah.
Shut up.
Well, depends on your definition of cold, and are we talking about
That's right.
on the absolute scale?
Even the
or
lawyers have their hands in their own
own pockets. That's right.
That's how cold it is today.
All of you listening, that was my joke. I'm
Yes,
making fun of
Blake-
myself. I'm not
Blake
offended.
brought that to the
Yeah.
table today.
Yeah. Okay. All
So I thought I was going to get hired at Holmes Murphy, who
Okay.
they have a subsidiary called Innovative Captive Services. I don't know if you've delved into the captive insurance world.
no,
Okay.
definitely not. I have no idea. what
And
it
that's
is.
probably in the weeds here, but the short version, it's pretty prevalent in the construction industry where it's difficult to go and purchase a policy. Premiums are expensive. Maybe the products don't fit you exactly as a construction company. But if you have a good track record of safety, you're responsible, you're competent, you're all of these things, you can actually set up your own insurance company. And then
Oh, I did. No,
it's-
no, I didn't.
now, mind you, I'm
is
giving
this-
that 30,000 foot
Sure,
version
sure.
of it,
But is this similar to when someone says we're self-insured?
no. I mean,
Okay, yeah. Self-insured is just like, I got enough money that I don't worry about it.
correct. This is
Okay.
more like, hey, you, me, 3, 4, 5, 10, 50 other contractors around the country, we're going to band together and make our own captive and pay premiums into it and profit share if we have good safety records, that sort of thing.
Okay.
Okay, so I thought I was going to get hired there. It ended up, for various reasons, not working. But I had a buddy who was familiar with Baker Group, and he said, hey, they're looking for an attorney. And so
You're like, what's a Baker Group?
something,
Yeah, something like that.
I don't want to admit it, but yeah. The electric guys. No, not the red vans.
yeah. Oh, yeah. You're like, yeah. Do they drive the red trucks?
No, and then
Yeah, my
EMC
nephew works there. That's the other one.
That's the other one.
I have a friend who is general counsel with EMC Insurance, and I checked in with him. Hey, what about this? And he said, no, not a good fit here right now, but Baker Group's hiring, and because he was familiar with Baker Group.
Okay.
And so eventually I thought, you know what, I'll give it a whirl. It's business, it's transactional. And the first response, I mean, we don't get too into the weeds here, but you don't have enough construction experience. And I thought, you're right.
You're right.
I don't.
That's fair. That's
I
fair. That's a
have
fair criticism.
little to none touche. And so fortunately had a couple
Well, they make you like push a broom and like solder pipe. I mean, what'd they do here?
No. So eventually, a couple contacts on the inside who helped me get through
Okay.
the hiring department. Got my name pulled out of the resume stack.
Okay.
Got the interviews. Convinced Baker Group leadership that I could learn construction law. So I've immersed myself in it for the last
Year and a half. Yeah.
Year and a half.
Yeah.
year
So
and a half.
so now we're back to when I say the position was VE'd.
V.
Now,
Okay.
now hopefully it makes a little more sense.
It does make a little more sense.
Yeah.
You're not really what we're looking for.
So yeah, if you want to end the podcast now, I
no,
fully
no,
understand.
That's all right.
You con
Right.
380.
So-
I don't know what that means.
Wait, now you have to understand. I know most of these guys at Baker Group for years and years. I could literally see them thinking, this guy doesn't know what he's doing, but I bet we could hire him cheap. You think we could? Oh yeah.
Yeah, they tell
Okay.
me it was
Yeah,
a culture thing, but I
it was
got
a culture thing?
I got
Yeah.
a feeling it might be that.
That's probably what it was. They're like, hey, I think he'd work cheap. Okay, we'll take it. We'll take it. We'll take a risk on him.
So but my motivations were
Yeah, Dale's laughing because he knows it's true. He's like,
If it were, I would be laughing. Anyway.
so. Here's what I like about it. One, people are great. Just to give Baker Group a plug, fantastic company. I've had nothing but a great time, patience. But when you're litigating, you're fighting, right?
yeah, it's full contact sport.
And it's nasty and it's stressful, and you take other companies, people and people's worst experiences and make them your own. And it's stressful. It's not fun, and it make your hair go gray. And I knew I wanted to get back to transactional. And why? Well, construction's a good example. A lot of what we're doing is we're trying to head off any dispute early on with contracts. We're trying to write them and equitably share risk so that the rules are clear. We all know what's going to happen if XYZ happens. It's collaborative. Most of my legal work now is at the beginning of a project prior to a dispute. It's much more enjoyable to me. And even if there is a dispute, most of my work is still pre-litigation. It's alternative dispute resolution. It's just phone calls
Ooh,
with leadership.
now that's something that we discuss quite a bit.
Yeah.
In the class is mediation, arbitration,
Yep.
litigation. What are the three different things? How do you
Yep. Yep.
When is which one called for? I don't know. Would
Sure.
you say that mediation is probably the most common
Yes.
in construction?
Yeah. It's particularly non-binding mediation.
Okay. Well, explain that for like our sophomore here. He's probably like, I don't know what any of this means.
Okay.
Why don't you talk about what mediation, what makes a good mediation? When's it necessary? How do we get there, and how do we get out of it?
Right.
Get there, get it done, and move on.
So I can kind of come at this from two angles. One is I've been in, hundreds of mediations over the course of my career, not necessarily in construction. So generally speaking, the difference between, you might hear the term ADR or alternative dispute resolution. These are methods of resolving a dispute that do not include litigation. So litigation is I'm company A or I'm company B or I'm person A, and I file a lawsuit with the courts of the state or the courts of the federal system. There's different court systems, right? So that would be litigation. Litigation, you'll find, is most likely the last resort for most folks these days. Why?
And for the students, the reason being here, so you have to understand this. By the time that you're in litigation, everybody's lost, and
Yep.
you're just trying to figure out how much.
Yep.
And the problem with litigation is it becomes its own financial liability.
Yes.
Merely defending yourself, even if you're in the right, even if you're convinced, oh, I've done everything right, and I really don't have any liability here, or I've been wronged and I think they should pay for it.
Yeah.
The deal is that you could easily run into lawyer fees far more than maybe
Yeah.
the damages. I mean, it's not unheard of for a serious construction litigation. I don't, six-figure legal fees are not uncommon at
No.
all. It'd be hard to
No.
get it done for less than $100,000, to be honest.
Absolutely.
And you
Yeah.
could easily run into, legal fees upwards of $500,000, $1 million before you even know it.
Yep.
Right? So avoiding that, the whole point is that avoiding that should be personal opinion, not as a lawyer, but just as someone
Right.
in construction. The idea is to avoid getting to that point where you have burned all these bridges, nobody's interested in working
Yeah.
things out, and you're like, you know what, we're just going to let the lawyers fight it out because I hate you, you hate me.
Yeah.
Talk to the lawyer.
Yeah. Usually there's some ego in play. I won't denigrate the courts. I think they do a fantastic job, better than the media rap gives them. But it is long and it's an expensive process.
It's expensive. It's
So-
expensive.
Alternatively, you can, let's say I'm just car crash parties, right? Injured party, at-fault party. We can voluntarily say, you know what, let's go get a third-party neutral who we'll write letters to them, we'll present our evidence, we'll get in a room and discuss this, or maybe we'll sit in separate rooms and the person will go between and try and resolve this. And it doesn't have to be binding, meaning you don't have to walk out of there with a resolution. But a mediator would go in there with the sole goal of bringing two parties that are here and here together.
The idea, good mediation, or at least my opinion when I've watched it, good mediation probably results in neither party being terribly happy.
Nobody should win.
Yeah,
That's a good
that's
settlement.
that is typically what people would agree to as a good settlement.
I didn't get enough, and I paid too much.
Yeah,
If you hear
yeah,
those,
yep. If
there you
both,
go.
if both of them are little or mostly unhappy,
Yeah.
that's
So-
probably good mediation.
So arbitration is a step up in that usually it's binding. There's different variants of it. There's different organizations that do it, but usually you end up with a panel of 1, 3, 5 experts in whatever industry your dispute is. It's almost like a mini trial, so to speak.
Yeah, the way I describe it in class when we go
Yeah.
through these is there is a winner and a loser.
Yep.
There is a judgment.
Yep.
The whole point here is to skip the full bore jury and maybe years that a trial could take. But we're unhappy, and we want somebody to decide who's right and who's wrong.
Correct.
And give us a judgment.
Yep.
Okay, and that's so think of the three that I describe in class. There's mediation, arbitration, litigation in that order of complexity, in that order of cost, and in that order of time.
All correct.
All right. Okay.
I agree with all of it. And so relevant to me as in-house counsel, you can set these up contractually before you ever begin the project.
What would a good contract look like from a contractor's, like you guys are subcontractors, what would a good contract that you're going to write with either a general contractor or maybe with an owner, because you guys do a lot of work directly with owners.
Yep.
What does that look like when you say a good contract to avoid litigation? What kind of clauses or things would you be looking for?
So what you might hear from me often is clarity is king in a contract. The clearer you can write your language and spell out what should happen in the event of a dispute, the better. And so what I like to see, and not every attorney may agree with me, but I want to see a clear notice provision and then clear deadlines of how long somebody has to respond. Then the project teams have to have a discussion within X amount of days. If they can't resolve it, senior leadership has to get involved. You'd be surprised. It seems like in a year and a half, that solves a lot of problems because they know.
It's like,
Well, they just know that we can head this off now and we'll probably come out ahead, both sides, money-wise, if we just have a clear discussion now. And if that doesn't work, I'm a believer in mediation. I like to see mediation, then arbitration.
I don't know if, and this might get into client stuff that you don't want to, and please don't feel like to mention who the parties are. But do you have any examples of what that like disputes that you've been in, and it's like, okay, good mediation kind of saved us problems, or kind of made life better, or at least got us out of making things worse?
Ask me again in a couple of years. I think.
Okay. All right.
I mean, like I said, I've only been there a year and a half. And
okay.
So
All right. Well, that's fair. Okay.
Are you talking at Baker Group or just in his
career?
It
could be either. Could be either.
Career. Career. Yeah.
Career. But Baker Group. If I don't know if Dale's got any examples there. Either way.
Career-wise, one thing we didn't really touch on. I liked mediation particularly. I already knew what the case was worth, and so did the defense counsel. Half the problem I was kind of alluding to it with egos is you got to get your clients to understand.
Yeah.
And so a good mediator is able to speak truth softly to each party and get them to see the flaws in their case and even consider compromise. And I've seen that countless times. That's happened. Yeah.
All right.
I don't have any great
you don't have it? Okay.
stories,
Okay. All right.
I mean, if I do, it's really kind of boring,
Yeah.
dollar figures and whatnot. Yeah.
All right.
So.
Okay. So I guess so. What would things that as an attorney, that advice that you would give, for like our student here, after he's graduating, he's heading towards management at some level. It's going to be a trip. Right, but what are the legal things? It's like, when does he need to talk to the in-house counsel? What can he do? In other words, how can he make his career a little smoother with a little bit of good planning ahead of time to keep him from having to get to either one of those litigation, arbitration, mediation kind of steps?
Sure. Maybe let me attack it from this way. Right. So a lot of what my job is trying to identify and help resolve or mitigate risk, right? So the possibility of a bad outcome due to future uncertainty, so to speak. So I would tell you that there is a hierarchy of how to deal with risk. Okay, so one, if you're in the construction industry, is your go, no-go selection process. Is this a project I want, not want? Identifying all the factors that may be in play. Picking good projects. Okay.
Does that mean picking good? Does that mean picking good owners, picking good architects, picking good engineers, all of the above?
Yes.
Are there some that you would prefer to work with and some that you would not touch with a 10-foot pole?
Well, I deferred to our business development department on that, and they're great. But I believe they have answers to all those. No-go lists.
Yeah.
But there's more to it. Schedule, payment timelines.
Yeah,
Look-
we've got experiences with a lot of different building owners and general contractors and other trade partners and designers and architects, and almost never do you have the exact same combination.
Oh,
Say,
no, yeah, true.
And so
yeah,
it's
yeah.
maybe there's a particular architect that you've struggled with projects in the past with that architect, with the quality of the documents that come out, or a designer or something, and you always and forever until you need work again say, hey, if this designer is involved in this project, we're not even going to look at it, type of thing. And so Blake mentioned our go no go process, and that's really figuring out the work that you're involved in. Now, as a student coming out of the Con-E program, I don't know how many years it is before you get involved in deciding which projects your company is going to pursue or not pursue. So typically, a new graduate's going to be plugged into a project that's already on the books, it's rolling, and so you don't have a lot of impact on that. But paying attention as you're doing those projects, the contract documents, a lot of the time the rub comes with a schedule. Hey, the building owner needs this done by May, and we're off track by 6 months. What are the liquidated damages? How expensive is that? What's the risk? And if your company looks at that and says, hey, we're off track and we're going to be in trouble, what are the things you can do early in the project or whatever stage you are in the project to document whatever delays you have? Become really important.
Here's something.
Being able to say,
Yeah.
produce documents to say, hey, 4 months ago, we sent this this question to this team member that we need this information back by this date, or here's the delays, and being able to be clear about what those conversations were. If it's documented, it exists. If it's conversation, it's just vapor. So conversations don't hold any weight. It's got to be documented.
There's a good thing here. Let me give you an example of an expert witness I was on where it was a heat pump system, and for whatever reason, within like not even 10 years of the building being turned over to the owner, it's leaking everywhere. It's like eating through all the coils, like every pipe and valve. They're all leaking. And owner paid a contractor to rip it all out and replace it. After they threw it all away, then they started to sue. Then they got mad and they're like, hey, that shouldn't happen. We're angry. We're going to sue. So lawyer brings me in, to do this. And I was like, what am I looking at? How am I going to even make the case? But here, interesting fact is that I'm like, okay, so I'm talking to the maintenance guys, and I'm asking them about chemistry and water treatment and stuff. And they're like, well, we didn't do any. And I'm like, what do you mean you didn't do any? And they're like, well, there was no chemical addition pot. There was no chem pot to even add chemical to it. I was like, that's effed up, And I mean,
that, Blake? You believe
No,
that?
it's unbelievable.
Yeah, I know. So, yeah, okay, so, right. But anyway, so Dale's like, yeah, how would you do chemistry without any chemistry? So anyway, so I didn't have a lot to go on because all the stuff had been thrown away. So I had what I could do is like, okay, this was required by the contract. It didn't happen. That therefore all of the, all the owner training on chemistry control and the whole thing that was required by contract didn't happen because it couldn't without the, the way to add chemicals. So you're like, I'm getting this list of things that's like, well, you are owed this and this and this and this, and this didn't happen, and we can still prove that even though you threw away all the leaking coils and stuff, the part with the pumps and say. The contractor found an email where they asked the owner if they wanted the chemical addition equipment. And the email literally said, no, we don't want that. So go ahead and just eliminate that and credit them a couple of bucks. I'm like, oh, my Lord, gone.
Done.
Lawsuit gone.
That's
lawsuit, yeah.
So
it's like they found the one email, and it wasn't even like meeting minutes or anything. It wasn't a change order. It was just an email. Where do you want this? We've decided we don't want it. Are you sure? Yes, we are. Okay, guess what? Lawsuit gone.
So I feel like we're jumping a little bit ahead as far as how a PM can help in-house counsel, which was your question, and I was answering it in a long-winded way. I'll be more direct.
Okay.
Come to me early. Okay.
Yeah.
When you get the project and you've been presented, see, we're a subcontractor, so the contract is often presented to us. Let's talk about it, or at least let me know 3 things I'm particularly concerned about. Are you okay with the pricing method? You understand it all? If it's cost plus, are you okay with the disallowed costs? Let's have a conversation about that and make sure that the contract matches your expectations and what you want it to say. 2, scope. We've already gone over the fact that I did not come through the construction program. That is not my area of expertise. I rely heavily on project managers, people actually doing the work. Is this describing what you've agreed to do for the price we just discussed? Are all the inclusions, exclusions that were in your proposal, which have now invariably been thrown out and not included in the contract, are they there? I want to know that. And then Dale was touching on it, schedule. I need to know, are you okay with the schedule? And that I need to know that for several reasons. Liquidated damages is one. You can have liquidated damages for us to the GC. You could owe them to both the GC and the owner. But I really care more because I want to put contract language in there that gives us a right to adjust the schedule as the project is going along. So let's do an ounce of prevention up front, which is better than a pound of cure later, right? And so because the contract will generally be king throughout the project. Now,
Once you agree to it, right? And something key here, I think, is kind of a topic that we were discussing when the students were talking about job offers, is that, you know what? Business is negotiable.
Yeah.
Just because someone gave you this, I'm reading between the lines, and what you're telling people is, don't sign it and then let me review it.
No. and I just about fall off my chair.
This is happening.
So okay.
Signed.
Can I vent for a moment?
Please, yes. Oh,
Let her rip.
hell yeah, let her rip. That's what this is for, man.
My first year there.
The reason you're at this table is Brad said, "Hey, you have an in-house counsel?" I said, "Yeah."
Yeah.
And he said, "I bet he's miserable.
He
He needs an outlet. Let's get him in here and let him
good
vent."
therapy.
So this is really like an intervention.
Yeah.
All right. So
Let her rip.
project managers, if you've already started the work, and
he's only been there a year and a half, and he's like,
if you finished the damn job already, let me know.
That's not a thing. That can't be.
Oh, no.
Yeah.
I mean, no, never happened.
Okay.
Maybe it's happened. Where
Okay.
now I'm like, well, okay, now all I care about is warranty or
Warranty.
my review is now much less.
That's
You're done with the work. I don't care about this giant change order section anymore.
Yeah.
But no. Yes, everything's negotiable. Now, you're only as smart as your dumbest competitor. So, to some extent, not everything is negotiable.
Oh, well, okay.
You see what I'm
right.
saying?
In other words, if there's some things you just can't get a contract,
Yeah.
I mean, you got to have a contract to manage it.
Hey, maybe I'm saying is the bargaining power is not equal in a construction project. If you're the owner, great. GC, also not bad. It'd be much easier to be in-house counsel with a general contractor than a subcontractor. And because we're kind of in a difficult spot of, you don't want to do the mechanical work, Baker? You're not the only one. We just go find somebody else to do it.
Yeah.
Now, there's always that tension for me as in-house counsel of, hey, let's sand off the rough edges of this contract. Let's just try and make it a little more equitable. So that's one thing. But the other thing I got to get in here is if you're a project manager or you're getting into the industry is you do need to know certain parts of that contract. I think there's an old, not necessarily an adage, but attitude of it's signed, throw it in the drawer. Let's never look at it again. If you have to, there's problems. And there's a lot of truth to that because relationships are very important, particularly here in central Iowa or even this region. But there are a lot of notice deadlines in there that you can certainly help your negotiating position if you've complied with them. There's a change in circumstance. My God, you've probably seen these. That you have 48 hours to let us know via written notice, which has to be facsimiled. I mean, your students may not even know.
Yeah, do you know what a fax is, my man?
I don't know how to send a fax. So, you know,
I actually had someone. Oh, what was? Yeah, I was. This actually came up where it was one of the lawyers I was working for said, "Well, you can fax this back," and I was like, "What are you talking about? You know, fax? I don't even know where to find a fax." They're like, "Oh, well, that's still considered a what is the fax is still considered secure or you know for signing stuff." I'm
akin to certified mail.
Yes, akin to certified mail, and they're like, "Yeah, we have a fax," and I was like, "I don't even know where to find one."
So, you know, just bringing it to your question, how can you help in-house counsel? Let's talk about the contract. Let's make sure you're okay with it. Let's make sure that you understand your obligations under it. And then I think what you guys were starting to talk about, and I wholeheartedly agree, is if a dispute or an issue arises, you're going to have documentation. Where was the project? What was being done? What was the cause of the delay? Where did you have troubles? All of this documentation I will ask for, and it gets very frustrating when it doesn't exist. I just talked to him. I said, "Well, damn it, I can't present that." I mean, I put.
Yeah, it doesn't go anywhere. I do the same as expert witness. That's the first thing I do. I'm like, all right, what do you got for me to read? What do you got for me to see? What do you got? You know, and it's like, and if you don't, if it's just an owner is like, well, they said this and they didn't deliver this. I'm like, what am I supposed to do with that?
I know.
You know,
so
and I know in a lot of old, you know, doing what you say you're going to do is a value.
Yeah.
Right. And yes, if I say, you know, this or this or this, that is binding. However, it is so difficult to prove after the fact.
So one of the things that part of my job, right, I have a lot of roles as in-house counsel. One of them is dealing with contracts. But one of them is just helping guide the project management teams on some of these issues of, okay, here's what the contract says. Here's what you have to do within X amount of time. But it doesn't have to be this formal, litigious lawyer garbage. Why don't you just call your counterpart, have the conversation, work out a solution, and then send an email saying, "Hey, thanks for that phone call. We agreed to X, Y, Z." Now you got it. And
something as simple as that. Something as simple as that. Actually, one thing that that is still binding is that, like, if you take notes, if you've got, like, as a student, maybe you're working, working on the job site. Maybe all you're doing is some days just answering phones or whatever. Mm-hmm. But my point is that a call log. I know I was pretty. Not at Iowa State now, but when I was an engineer, we were all highly encouraged to have like a notebook and a call log. Who did you talk to? What day was it? Roughly, what did you say? That is admissible type stuff.
Yeah.
If you're like, well, I had this conversation with this person on this day. Really? Yeah. See, here's my call log. You know, and here a notebook that you can't take paper in and out of. Not like a 3-ring binder. I mean, like an actual paper notebook.
Yeah.
Is amazing how good that is for later proving what was said, what the conversations you had. That's actually very good stuff. But
and I feel like some of the professions are maybe better at this for different reasons. Let me just take the legal profession. You work in a firm, you got this software already set up. Somebody calls, a couple clicks of the button, you're timing it. You want to bill it, right?
Okay. There, let's get to the attorney part.
Let's be honest.
I got to send a bill.
So it can be done. And then you store all your emails. But part of it is just covering your ass, right? Because you could be sued for malpractice if you're, or an engineer. So you get this documentation habit down a little bit better. So it can be done. I mean, and I think it's, to the extent we can start to implement that, it's helpful.
Well, that's one of the reasons in 241, the class that he's in, one of the things that we stress in labs, not for the purpose of legal sort of for the purpose, for someday. Mm-hmm. The habit that we want to get the students into is documenting what it is you're doing. Mm-hmm. And yes, in 241, it's literally just like, how many cubic yards of dirt are we moving? Well, if the hole is this deep and this wide and this long, but the point is to get in those good habits of writing it down and making it clear so that somebody that doesn't know you, not really familiar with your project, could look at this a month, a year, a decade later, understand what you did, why you did it, how you came up with your numbers. See, that's good practice. That was kind of the standard when I was at Black & Veatch. We were designing, and this is the extreme case. We were designing nuclear power plant, and you had to document everything. I mean, everything with like I did it. This person checked it. This person checked that they checked it, and we've got signatures and the whole thing. That's the extreme case. Right. But those habits were very good for me in the consulting world, because now I got in the habit of calculating and writing it down, so that I would have a record later. And that is just a good habit to be in, so that as they're, it's like, oh, here's this moment, I might have to go talk to legal counsel.
Right.
And then when you're asking, all right, what do you have? It's like, well, by the way, I've got this. Or you do something and he slaps his head. This is not what you want. You don't want, if your lawyer is slapping their head, that is a bad day. I'm just saying.
So I hope Dale will back me up on this. I work very hard. I want the entire company to not look at me as legal. Like, I am Team Baker. Like, I have one client, Baker Group. And I want to
roll up. Show him your tattoo.
Tattoo.
Right?
I think that's a thing, right?
Yeah.
I think that's after your third internship, though.
So, point is, just come talk to me.
I agree.
I mean, come to me early. You're starting to get a little worried about the schedule. Things are slipping. Let's just have a little quick gander at that contract.
Before Blake came to Baker Group, we didn't have any legal in-house counsel.
Yeah.
So as a company, we've grown, and certain size company, you have to be of a certain size to be able to have in-house legal counsel. You can't be a two-man shop and say, hey, we're going to have an in-house. But having in-house legal counsel is extremely, extremely valuable, because before Blake showed up, and Blake is the right personality. The reason we were interviewing two different people, Blake was a better cultural fit. The other person had better construction experience, but Blake was a better cultural fit. His personality and our collective.
And he was cheaper.
And
he was cheaper.
And I don't know if he was cheaper or not, but he was personality-wise, he's a much better fit for the way we wanted to have somebody in that chair conduct themselves, as opposed to somebody that just wanted to go to battle every day and pick a fight with somebody. And so. That is the way Blake isn't viewed as somebody that wants to pick a fight every day. He's seen as a resource. People want to go, and he'll help them learn. But before Blake showed up, we had started to spend more and more dollars externally on legal resources for just handling things, just because of the scale of what we were doing. And we would like DIY lawyer stuff. We'd try and figure it out on our own. Because it's really expensive to send it. Well, we got to call up so and so, and it's $350 an hour. We can probably figure this one out on our own.
Right.
And so having him in house has been a really big asset for us. It speeds it up tremendously. Instead of taking 3 months with 4 or 5 different conversations and conference calls, you can figure out in an afternoon. So it speeds it up, and then also we're less resistant to pull in somebody that's a legal expert, because Blake's a legal expert and he's right there, and that's what he's there for. So it's a huge asset for us, and he's done a great job of doing some in-house lunch and learn sessions on here's what you look for if you're a project manager, for indemnification clauses and all this weird stuff. If you bump into this, come see me. So it's been a shot in the arm for us, for sure.
Did you get to talk about indemnity in your common law class?
Not like the term. Not much.
Yeah.
I mean, did you want to embellish a little bit on that?
No, people fall asleep. I can't.
What's that?
I can't if you want.
If they're still awake right now, then
It's been that bad, has it?
No. No, it's good learning stuff. I mean, these are things.
Yeah.
So these are things that we don't necessarily have a whole lot of time to discuss on this level in a class.
Can I give you an example?
Please.
He said lunch and learn. So
yeah.
So part of my, like I told you, dealing with legal issues, but also educating. So submittal liability. I gave a little presentation on submittal liability for us. It's you send it upstream to the GC, to the engineer. It gets stamped approved. Boom, you think you're good.
Yeah. Oh, please.
No, you're not.
Yeah. No, okay. Thank you.
No, you're not.
Thank you. This is literally a topic. Like I teach some I teach some classes for Master Builders of Iowa, and one of the it's on plan reading ostensibly, but we always get into specs a little bit and the role of shop drawings and why there's a here. The important thing is shop drawings are not a way to change a contract.
No, they're not.
And just because an engineer maybe or an architect maybe stamped the shop drawing approved, it does not necessarily mean that they are that they are agreeing that whatever in that shop drawing supersedes whatever was in your contract. That is not a thing. But anyway,
so no, I wholeheartedly agree with you. I mean, to make a conversation that could be an hour long, 2 minutes. You get your plans and specs, your designs, and then they get your final copy, and the GC is going to go build it. The GC's contract to the subcontractor, which is Baker Group's position, will almost always say, you got to submit your shop drawings, right? All your submittals and shop drawings are one of those. And they're going to either be approved as noted, rejected. And when those come back to you, though, that all they're doing, the GC, I'm not, frankly, maybe somebody else can tell me, I'm not sure what they're doing, but the engineer, they're just checking to see if it conforms to the general intent of the project that they've designed. And they might be getting more nitty-gritty than that, but it's not.
I mean, as someone that's checked a whole lot of shop drawings, you're not wrong there. I mean now, because here for the engineer, the important thing to understand is that if they're checking shop drawings, they're like 2-3 projects on down the road from designing this.
Right.
And their mind is not on wow, I need to look at every word in the shop drawing. Right. Their mindset is like, I think I might have the intern check this because I'm really busy with designing this next thing.
Okay, now that has its own engineering liability issues.
Okay, well, shush. I mean, I'm just saying.
And we can talk about like the Hyatt Regency case.
Okay, well, which no, I've already done a case study on that.
Have
You're
you?
exactly right.
We won't get into that.
Oh, there's a lot of bad in the Hyatt Regency. Yeah, go ahead.
But you're absolutely correct that this needs to be understood. The shop drawing is not a contract document.
Right.
It will not be a binding thing that you can use to develop or to resolve a dispute as far as rights and obligations. You approved, you didn't approve.
Right.
It's just the subcontractor saying this is how we're interpreting or how we intend to build what you've designed for us. Yes, no, yes.
Yeah.
Okay. But what Baker Group, and I'm trying to explain to our PMs, is you have a role here because correct me if I'm wrong, but it seems to be we send it to the vendor. Hey, here's the plan specs. I need something that conforms.
Yeah.
And then they come up with the shop drawings, which they funnel through us.
Right.
But depending on how the contract language is written, right, because the GC is going to give us a contract that says we're responsible, and then we're going to give. What are we going to give? We're going to give a PO. What are our PO terms? Well, how did you write it? Did you just put furnish equipment on here, or did you put more? I mean, there's a wastewater treatment plant case out of Cedar Rapids you may be familiar with that is on this exact issue.
I think. Okay, go ahead. Go ahead. I think I've heard of it, but
it had to do. What was the name? It's some wastewater expert GC out of Minnesota. Rice Lake, maybe. I'm not sure if you've heard of them. But they got caught ripping out these motors that they had ordered and having to pay for them twice, and then delays, because by the time you screw something up, now you got delays. Mm-hmm. And then you're just hoping you have a consequential damage waiver in your contract. You get to talk about those in
No, absolutely not. That is kind of
too
deep. That's getting pretty deep.
Okay, let's just hit it in one
moment.
You're building a casino, right?
Right.
You screw up. Do you owe the casino owner the cost to replace it, a direct cost, or do you also owe them consequential costs, the profits they would have made if the casino had been open on time?
Well, I guarantee you.
You screwed up the whole casino? You're rebuilding or you just delayed the opening by a month?
Well, you delayed it because you got to fix some defective work, right? Okay. So that's going to have its cost. But
I know the casino owner's position on that.
Well, because it's going to depend what you agree to.
Yeah, that's true.
What's on the paper?
Yeah. Well, the casino owner here, I've probably designed more casinos than most any other engineer in the state of Iowa. Oh. Casino owners know exactly how much they're making. They don't gamble.
Well, and it's not
No,
a small
it's-
amount.
Yeah, no, well, yeah, it's not a small amount. They know it per minute
Yeah.
based on time of year, time of day, time of week.
Yeah.
And they don't gamble. They know how much they're making.
Yeah.
It is amazing, and they're only on a construction project. The only time they understand is sooner. There is nothing else in their mindset. So
Yeah.
on something like that,
Yeah.
I could almost tell you how they will probably write it.
Well, sure.
Is for those consequential damages,
Which
because-
is, I mean, I agree. If I'm the owner, that's exactly what I'm writing.
Yeah.
But
All right.
all right. But indemnity. You know what it is? An indemnity contract. Everyone will understand.
What?
Auto insurance.
Okay.
That is an
Nope.
indemnity contract. So you are contracting with another party to pick up your negligence.
Yes. Okay. Okay.
If I hit somebody, I don't have to pay out of my own pocket the damages that I caused. My insurance company is going to step in and pick up my liability. Okay, so it's a risk shifting mechanism that
Right.
that you're going to find in engineering contracts. You're going to find them in subcontractors. Everybody uses them. They're ubiquitous. They're everywhere.
Yeah.
So you should understand them. But the point on that is that if you're in Iowa, you can. They're limited. There's a statutory fix where if you're outside of the state, maybe something breaks, you broke it, I could still have to pick up the cost. Whereas in Iowa, we each have to indemnify. Let's say you get sued. A student gets hurt in your class. They sue you as the professor, the captain of the ship. I'm just making this up.
Sure.
But really, I'm the one who hurt them.
Uh-huh.
You could come to me if there's a contract and say, look, you agreed to indemnify me for things that you caused. So
Yes. So that includes legal fees.
why
and
don't
the
you
whole
go
thing.
ahead here
Yeah.
and step in and deal with this lawsuit?
Ooh.
I mean, that's what we're talking
Fun
about.
fact about that indemnification thing in auto insurance, right?
Yeah.
Fun fact is that if you're the person that is hit by another driver and their insurance company is less than equitable about their settlement, you can't sue the insurance company directly. You have to sue the person, and then the
Yes.
insurance company indemnifies you. And the
Yeah.
reason I know
Yeah.
this
You're right.
is that I was hit. Our bus, we were hit in a parking in a campground. It was in Nebraska. We were parked out in the Cabela's all the way out west in Nebraska. Guy with a brand new truck and trailer. We're parked. They're going around, and we were the last camper in this line. And he was new to this particular trailer and didn't understand that when you're turning in a trailer, the trailer cuts the corner a little sharper.
Oh, yeah.
Hits us in the hits the bus. Anyway, the long story short is when we called the police, got the documentation, whole thing, fine, go to bed. Unfortunately, it was I won't say which insurance company, but they have this little lizard as a mascot. Anyway, lizard insurance.
Yeah.
Okay. So they're terrible. Like when I called my insurance company, I'm like, hey, I got hit. He's like, okay, who was it? What was their company? I give it to him. He goes, oh God.
Okay, here's the quick
Yeah.
rule of thumb. The bigger they are,
Yeah.
and the cheaper the premium.
The worst.
I'm not denigrating any particular company.
Of course not. We're
But
not mentioning it
as a function of business, if I'm taking in less in premiums, I'm gonna have to defend harder to not
and
make
cut corners.
payouts.
Yes, and so the bus ended up being broken down in Nebraska, western Nebraska.
Oh, what's
Terrible.
out there?
Nothing, nothing, and nothing. I mean, we are like, do you know how many tow trucks exist in western Nebraska that can pick up a 40,000 pound vehicle?
No.
There's two.
Ah,
Two in all of western Nebraska, both of which.
Two more than I thought.
Exactly, right? But there's a lot of semis out that way. So
Oh,
there's
fair,
like,
fair.
so
Yeah.
so I have to get a tow truck that can pick up a 40,000 pound vehicle from 150 miles away. So you can imagine the towing bill and everything. And long story short, I had to file with my own insurance company as if I was hit by an uninsured motorist. because they didn't settle all this for it was over a year.
Yeah.
And, I didn't get anything. Here we are temporarily. We're stuck out there. We have to get rental, like a hotel to stay out there and rental and all the stuff. And the Lizard insurance wouldn't pay any of that. And I'm like, finally, I'm just like so furious with this. I'm like, I file a lawsuit against Lizard Insurance.
Okay.
Right.
Who
and
insures
I filed
the person who hit you?
Yeah. Who insures the person I hit him? And I filed it in a
a bad faith action?
Oh yeah. Oh, it was down here.
Okay.
So the funny part is that I knew it would not be successful, right?
Sure.
But I was just so furious at him. I'm like, I want something back at them. So I filed it in Boone County, Iowa court. And so at first I was like, what are the odds that they'll even send counsel to defend a small claims court case for like $4,990?
I'm guessing they would.
They did. Yeah,
Yeah.
they did.
Yeah.
They did. So they sent their counsel from Lincoln, Nebraska, all the way out there. And anyway, so I'm we're small claims court. Explaining to the judge what the issue was.
Yeah.
And then counsel for Lizard Insurance says, Your Honor, I'd just like to point out, I'd like to file a motion to dismiss this on the following basis, that there is no actionable item here in the court. He should have sued the driver of the vehicle because we don't have a contract with him, and on and on and on. And he goes through this whole legal thing about why they're not liable directly to me. And he was absolutely correct. And I knew it.
Yeah.
Right. And he's like, well, so attorney, counselor, would you agree that Mr. Perkins could file suit against the driver? He's like, yes, and we will defend them. And if he's successful, we will pay it out. And he's like, okay, Mr. Perkins, it looks like you have the wrong venue. And do you just have anything that you'd like to say? I said, yes, Your Honor. Of the counselor's brief, if we could turn to page 3, I would like him to read this paragraph out loud, because it talks about how this is an undue hardship for Lizard Insurance that is a multi-billion-dollar corporation. And he looks at me, he's like, Mr. Perkins, why would you like the counselor to read that? And I said, I would like to see if the counselor for Lizard Insurance can read that with a straight face.
I bet he could.
The judge couldn't. The judge cracked up. I mean, he totally lost it. He is like dying laughing. He's like, he tries to sober up. He's like, Mr. Perkins, I appreciate that.
That's funny.
But no, I'm not gonna have him read that.
Yeah.
Anyway, he's like, so we're dismissing that. And here's the awesome part is that in the hallway, so I leave, and the attorney for that insurance company catches me in the hallway. He goes, hey, I just want you to know, it's nothing personal, right? He's like, I just got to defend him, and
right.
You'll win if you sue, And I'm like, dude, here's the deal, right? I've got to go to their home county to sue. I'm like, do you know what this will cost me just to do this? I said, it's not worth it. But here's what's worth it to me. They had to pay you to drive all the way from Lincoln, Nebraska to Boone, Iowa, argue this, and drive all the way back. I just wanted to get some pound of flesh out of them and make them do it and try to make you say that in court. He dies laughing.
It's kind of funny. I would appreciate it.
He did. He's like, that is awesome. He's like, he goes, I appreciate the windshield time because I am charging them full price from the moment I left this morning to the moment I get back. He goes, you know what? You're probably right. Probably would have been cheaper for them to settle with you than to pay me to come out here. I'm like, thank you. It's not a win, but it makes me feel good.
Insurance
Makes me feel
companies, that's a whole discussion, but
well, and that's something that's probably a pretty big part of your job, isn't it?
It is. I mean, it might be kind of boring to students, but it is important because you can't escape risk.
No,
right? You can't make money without risk.
Actually,
but you can purchase insurance
to help mitigate
mitigate and protect against it. And you want a good insurance program. And if you're going out on your own, make sure you have a good broker you trust.
Yeah.
There's all sorts of horror stories, but let's just say you're an engineer. You can contractually agree to higher standard of care. We were talking about standard of care earlier. Your PE. Someone explained it to me once. You're licensed to be sued. Right? You're a professional now. You got a standard. Well, you can contractually extend your legal duties. But you got to make sure your insurance matches.
Yeah.
Because you can end up in a horror situation where you're being sued. You think you have insurance, but your insurance won't cover above and
Ooh,
beyond.
here, hold on that thought right there.
Yeah.
This reminds me of something that we talk about in class for the students that I would like to kind of touch on right now. Is that as a student, you do not appreciate how important your insurance is. And I'm looking at a couple of the students, right? I'm talking about automotive insurance, renter's insurance. This is a common thing.
Yes.
It is a lot of times students will look, well, I've got insurance. They are not all the same.
No.
They are not all the same, And when I was teaching this, I had students. I'm like, "What's your limit of liability on your policy?" And I literally had one student say like they were total for an accident. Their limit was like $100,000 or $200,000 bucks. And I'm like, "Are you serious?" I go, "What are the odds that you hit a car these days that are more than $100,000?"
Yeah.
They're like, "Well, what happens?" I'm like, "Well, you're on the hook for it now."
It's not there's areas to go cheap in life. I would say
Yes.
insurance is not one of them.
And I would say don't go cheap on it, and make sure that you're not going with a cheap company.
Yeah, you want someone who's actually, everybody's your good neighbor and great friend.
Yeah, Gary Fred. Yeah, until the rubber hits the road, you don't really know.
Yeah.
You don't really know if your insurance is any good until when you get hit.
So here, life
Yeah.
lesson
Yeah.
from a former life of mine outside of construction. People on the road, you would not believe the amount that, one, don't have insurance, which is illegal,
Which still happens.
but two, have insurance, and the legal amount of liability that they have to carry around right now is $20,000.
Oh,
Okay.
oh,
So
I didn't know that was the limit.
that's what you legally have to have.
Oh my gosh. Yeah.
So the fix is underinsurance.
That's what I had,
And,
and
it's
that's what
so
yeah.
cheap, you have to have
You
it.
have to have it. Here, every student that ever watches this, as soon as you're done,
Yeah.
pull out your insurance policy, see if you have underinsured and uninsured motorist
Yes.
insurance. You absolutely positively have to have it. If you got your insurance and you're like, wow, I got this super cheap, get a different company.
This insurance
your research.
is so boring. And I'm
I
sorry,
know, it's
but,
boring.
But it is important,
Right.
So,
Yeah.
well, at some point, we're starting to get more students. Speaking of life lessons, we got to hit restrictive covenants.
Oh, yeah. Yeah, we do. Here, okay.
Is it time for that talk?
Yes, it's time for that talk for restricted covenants and digital dirt. All right, so hold on a second. We are going to pause while we get these guys chairs.
Yep.
All right, now we've gained a couple of students here in the studio audience. They had to go to a class, but they're with us now. And we are going to talk about covenants and signing agreements for employment. You want to hit that one up?
Yep. So just as in-house counsel, I'm dealing with construction disputes, contracts, but it's more than that. And part of it is HR, employment law, right? So that's another area of the law. Hiring, this is, if you're going out and getting a job, here's the message I'm trying to send. You're going to be excited to get a job. You're going to be happy with what they're paying you. And you're probably going to be willing to do whatever they ask, if you like that job, and sign whatever they want you to sign. And I am suggesting that you read it.
No, not suggesting. The lawyer is saying to read it, and so am I.
Yes.
Read it.
Again, not personal advice for anybody, but
yeah.
it is very advisable to know what the hell you're signing. Not every company, but most will have a few things, right? And they're all called restrictive covenants. You agree to this employment, and in exchange, we'll pay you, and part of your promise to the employer is that you'll abide by these agreements. And the agreements will be a non-disclosure, which, fair enough. You're an engineer, you're an architect, you have IP, you got work product, you're Baker Group, you have all this sensitive trade secret data that you got to protect. You agree not to disclose it. Nobody has an issue with that. We get a little bit more dicey with solicitation, non-solicitation agreements. Do you guys talk about these?
No, that one, I don't mention that one. Go ahead and explain what that is.
So non-solicitation means you leave wherever you're at, and it can take various forms, and it can take various geography and time limits, but you agree not to solicit your former coworkers to come join you at your new spot, and you agree not to solicit your former customers that you might have developed relationships with when you were at your former place of employ. And there's definitely a place for it, a non-solicitation agreement, but it's something you need to be mindful of. I have friends who feel stuck at their jobs because they've developed this book of business. They can't take it with them. There's non-solicitations. So and the one that I want everyone to really understand is a non-compete agreement.
Hey, I have a question about that, but go ahead
Sure.
and explain that one, but I'll get to my question in a minute.
Okay, so non-compete has been a hot topic
Yeah.
in the legal world.
In the world, yeah.
Okay. The prior administration attempted to ban them. Just created, and we get into a bunch of legalese here, but Congress can create a law, and what we're seeing a lot now, the current one, is we're attempting to do a lot of things with executive orders, or the executive branches directing their agencies to make rules about X, Y, Z. And one of them that the prior administration tried to make was that a non-compete cannot be used. They're unenforceable. It got held up in the courts, and now it's gone. So they're back to being enforceable.
I was wondering where this was at, because
Yes.
I was confused as to whether or not a non-compete is binding or not binding. I was under the impression it was non-binding, but maybe it is?
It depends on your jurisdiction. In the state of Iowa,
Well, let's lay out the baseline definition of
Yeah,
when
we
say
need to explain this
non-compete,
for students.
so-
Yeah.
okay, sure. Good point, Dale. Thanks. So a non-compete is in exchange for employment and pay with an employer, you agree that you will not compete against them should you leave their employ in any manner. They're usually written whether I fire you or you resign, you will not go and compete against us. Now, there are limits on this, right? The employer has to have an interest that's recognized as protectable for it to be enforceable. They're disfavored by the courts, but they're all out there and they just cause headaches. It has to be a reasonable time limit. So in Iowa, we're probably talking 3 years or less. And it has to have logical geographic boundaries. So even the state of Iowa, though. So if you work for a company and you're in, say, the automation field, that's somewhat specialized, and they've put a lot of training into you, and you might not be able to go next door and take a better job offer and earn more money in that same field if you're going to be working for a competitor of your prior employer. And why is that important to me as in-house counsel? Because it becomes problematic legally if you have a contract at that point with your former employer that you're not going to go compete. Well, you can choose to break it, right, and hope that they don't sue you. Probably because you don't have a lot of money to get out of you. But the next company that you go to, well, now they might have some money. And if they're aware of that contract that you have with your former employer, hey, new employer, you're interfering with my contract with my employee, my former employee, you owe us money damages. Now, it's not easy to prove those damages, but it definitely, for somebody in my position, creates all sorts of headaches. When people say, hey, I want to come work for Baker Group, I have this non-compete. Now we got to analyze it. Can we hire you? What is the liability to you? Is it enforceable? Is it not enforceable? So the message, careful what you're signing.
No kidding, because here's the thing, is that once you've worked at, all right, we'll just use Baker Group as an example. You've worked at Baker Group, let's say you've worked there 5 years, 5 to 10 years, and you've gained reputation in Des Moines with owners and contractors and everything. And if you're going to leave Baker Group, the odds of you going to a similar company are pretty strong. I mean, what are you going to do that's,
Yes.
I actually remember, on one of the previous podcasts, I talked about how at my old employer, I really wanted to leave. I had that talk with my wife on the you need a different job,
Yep.
and I'm like, how am I gonna, because I had to non-compete. I'm like, what am I gonna do that isn't different?
Yeah.
And if it is the same thing, am I actually, is the non-compete gonna like squash what I'm doing? And how much would they take this, and would they be the bitter type that would send their legal counsel after you just to make an example of you so no one else
Yeah.
runs off the reservation? They're ugly.
Yeah.
And it's not in an era of people changing jobs maybe a lot more frequently than they would have, say, 30 years ago.
Yeah.
I mean, I think that's a fair statement.
Yes.
In an era where people are changing jobs a lot more frequently, and every employee represents a significant investment of time and money on behalf of the company that's hiring them. Non-competes can make your life pretty difficult if you want to live in the same town but work for somebody different.
Yep.
It can be pretty tough.
Yeah,
Right.
and I would say, especially if you've done the Connie program has a strong internship program and gets students plugged into internships. And if you've been an intern, for instance, at Baker Group for 2 or 3 years, and then you come and work, you get an offer in your hand to come and work full time. Don't just assume you're just going to roll, sign, and everything's going to be hunky dory. Give pause at that time and read any of that stuff that you're signing. And if you have questions, ask about it, because that basically sets the table for the insurance you choose, if there's any non-disclosure agreements, if there's all that stuff. It's a stack of stuff, and don't just sign it because you don't want to read through it. Figure out what's in there, and look into it and know what you're signing.
Yeah, there.
Especially if you're
signing.
I mean, what regardless of where you go, but especially if you do an internship and you're comfortable at a company.
Don't just sign it because
Don't
they
just
gave
sign
it
it.
to you.
Make sure you understand, because there's stuff that I've been at Baker Group since just after the turn of the century, 2003.
Wow.
So yeah.
Wow,
That's right.
look at that.
And so there's all sorts of stuff that we have now that we didn't then, that I've forgotten, that are there, aren't there. And so if somebody were working for me, I wouldn't even know, hey, make sure you read this. And our HR department, I'm talking specifically dialed in now about Baker Group, but our HR department is more than happy to pause and help you understand what that is. And if you're going to a company that you have an offer letter from and their HR department isn't willing to help you understand everything you're signing, you might consider, that might give you pause. But typically HR departments aren't out to get you. But
that's not always true, Dad. We've
help
worked
you.
at a place where HR is actually
All
out
right.
to get us.
But I don't think they all are. Some of them.
Not all of them.
Yeah,
All right,
it's
not
a
all
low
of them.
percentage.
I think this is indicative of a bigger conversation that is applicable to anybody in the construction industry, though. Just, you don't have to necessarily even change the contract, whether it be a construction contract, a subcontract, a non-compete. Maybe you just deal with the risk in dollars, all right? So we get a contract we don't like, a subcontract, maybe the price goes up a little bit. Maybe we deal with risk that way. Maybe you go to a job, not Baker, where you run into a non-compete, you know what it is now. Maybe your necessary compensation goes up just a little bit because you have a better understanding of what you're agreeing to. So you don't necessarily have to fight back even against the wording. You can, I recommend it, but money's another way to deal with risk.
Be paid for the risk that you're taking.
Exactly.
That is exactly. I mean, and that's what a contract is. Whether we're talking about employment, construction contract, subcontract,
Right.
You are being paid to assume risk. Part of that is understanding what risks that you're taking and getting what you feel is just compensation for said risk.
Right.
And if you're not, then that's a good warning. It's like, ooh, maybe I need to look at a different contract.
Yeah.
You know?
Yep.
All right. But now this is a chance for the students. Do you guys have like job offer, because we just reviewed yours.
We did, yeah.
And here, to anybody listening to this, if you're a senior and you're getting a job offer, you owe it to yourself to get at least one other person, preferably someone older that's looked at employment agreements. You need to have somebody help you review it. Everything from benefits to vacation to compensation to promises of bonuses and stock programs. You need to understand everything that's in there, especially if you've got a couple to compare and you're like, ooh, I don't know. This one, don't just look at the dollar value at the bottom. You really got to look at what's the total package here. And for the stuff you don't understand, get some help on it, because it is complicated stuff.
Can I offer another life lesson?
Absolutely.
If you're younger, especially, but even if you're junior, senior, find a mentor. For me in the legal profession, I would have been absolutely lost if I didn't have my mentor for the first 5, 7, 10 years that I could go to and ask a lot of these questions. So I don't know how you do it necessarily. Everybody's got a different way. Maybe it's an internship. Maybe it's you're knocking on doors. Maybe you have a relationship. But just try and cultivate a relationship with somebody that's been through what you're about to go through in the next decade or so. Do you guys agree with that?
Oh, wholeheartedly.
100%. And it's easiest to find mentors that are in the industry that you're in. Like if you've graduated and you're into the job now, it's easiest to find mentors in the industry. But I would encourage everybody to have at least, maybe five or six people that are a resource, and at least half of them are not in the industry that you're in.
Yeah.
Oh, good call. Yeah.
Have them that are in the industry, because they can talk to you about the history of the industry and things they've seen and not seen. But then also have mentors that are completely out of the industry that you're in.
Yeah, because you could take that advice and you could translate it to damn near anything that you want to talk about. Whether we're talking about buying a new house, buying a new car, getting married, health insurance, changing cities.
Right.
There's all sorts of things in your life that it feels like, oh man, I'm going through this and nobody understands. Yeah, probably somebody does. Probably somebody does.
And I say this, I'm 39, so I'm not that far out of college. Maybe I am. But I remember what it was like.
Oh, boy. Yeah.
You get all this.
Yeah, these guys are like, dude, this guy's old.
Hey,
Yeah. I still.
They're blurring the lines, 39.
Yeah, come on.
Dale, back me up on this. 39 to 50 happens in like 2 seconds.
Yeah.
Oh, dear.
Oh, God, yeah. Oh, I'm just warning you.
So you're one of us. I mean,
You're one of us.
Okay, I'm one of the old guys.
You're one of us.
My
You're one of the old
point
guys.
is, I'm sure somebody said that to me, and I was like, great, lovely. It's
Lovely.
Friday. I'm going to go to the bar. See you later.
Yeah.
All right?
Or it's Wednesday. I'm going to
It's
go to the
Wednesday.
bar.
I'm going to go to the bar. See you
Or
later.
Thursday. No,
You are getting
I-
old.
I-
You are getting old.
I look back and I see the value, and that's
Yeah.
why if you're in college, God, just take that time. I mean, it'll pay dividends for you, because you will get to 39 and you'll wish, okay. I mean, drinking was a hell of a lot of fun, but not sure
now
what
it
it did
hurts.
for. Not sure what it did for me
Yeah.
at the time. So
Oh, no, that's...
maybe this is a good time to talk about bad ideas with the internet.
Yeah. Actually, this is a good This is a good time. Okay, so there's this it's things that were different from Dale and I time. Yeah, probably to maybe to yours. But
here's how old I am, college
Okay.
students. When I was in college, Facebook was brand new, and you had to have a .edu email address to use it. And so
that is so cute.
Yeah.
Dale
That's
and I are
adorable.
like
That's adorable.
Facebook. Facebook existed.
all right, okay. There was a time though when we
Yes,
all
yeah.
used Facebook.
Oh,
And
yeah,
and
yeah,
we
yeah.
thought,
Well, we didn't. The young people.
okay, we as in me and my generation, we thought this will never see the light of the day. This is just for us on college campus. And the next thing you know, you got grandmas and grandpas on there, and everybody's looking at
And
your
then the
old
whole
photo.
place goes to hell.
And now I know it's just grandma and grandpa land. But whatever app you're using now, I'm so old, I don't even know. It could all change, and damn it, the internet is forever. Dale, you hire people.
yeah.
Maybe you talk about this.
Right. Dale? I mean, come on now. You hire people. You guys check.
Yeah,
Oh.
I don't know. I don't know. I don't personally. I don't know if anybody in our company,
Yeah.
maybe some in HR use it. If
Ooh,
on a
okay.
particular
Well, then
but
I
not
need
as
to
a but not as a
Okay, well-
policy. We don't.
I need
but-
to interject here then.
Yeah, jump in.
Because seeing this as a professor, some companies, and the larger the company is, the more likely this is true. A lot of companies hire vetting agencies, where they're like, "Hey, we're gonna hire Dan Kellen, right?" And they won't get. It is literally, we want you to dig into the digital dirt on Dan, and just give us a yes no. Don't tell us what you find, right? Because
Yeah.
they don't want to know. All they want from the vetting agency is you give us a thumbs up and thumbs down, and here's our criteria for what we want an employee to be, and here's the things that we would be concerned about. And if you find a certain number of these things that we're concerned about, you just tell us no. That's all we need.
Yeah.
And so they'll look at everything online and that they can find about you, everything.
Yeah.
Whether it's the social media or posts or whatever. And this is where this caught one of my students kind of unaware. So student comes to me one year, and it's not the recession, right? I mean, people are getting jobs, Maybe it wasn't quite as aggressive as it is today with job offers, but still pretty good time. And he was watching all of his friends here in Connie get jobs and take offers, and he still didn't have anything. And he comes to me, he's like, "Hey, Mr. Perkins, I don't understand, my GPA is better than all these other people, and I've been in AGC, and I've been in, I've got student orgs and internships, and yet nobody is offering me a job. I haven't even gotten one full-time hire." And I'm like, "Okay, all right, well, here, you got your resume? Let me see it." And he does. I'm like, "Okay, respectable GPA. He had internships, whole thing." I'm like, "I don't know." I'm like, "You're right. I'm not getting it." I'm like, and this is something that we had just had the discussion on digital dirt from the university come to our department. And it just made me think. I'm like, "Hey, you ever Google yourself?" And he's like, "No. Why?" I'm like, "I don't know. Let me see what I find." He's sitting across the table from me. I'm like, "Let me see what I find." And I look at him like, "Oh, I see you got a drinking problem." He's like, "What? What are you saying?" I said, "Well, it looks like you were arrested on drunken driving right here on this date." And he freaks out. He goes, No. I had an agreement, a plea deal that was supposed to go away in like 6 months or a year or something.
Getting expunged.
Getting expunged. Yeah. I said, "I'm not reading your criminal record. I'm reading what was put in the Ames Tribune."
Mm-hmm.
I'm like, you were arrested on this date. You were convicted. I found that you were convicted. Now, yes, maybe from your official criminal record, that's gone away, but it isn't going away from Ames Tribune. Yeah. And I said, he was wanting like a superintendent job, operating, being responsible for operating machinery and those types of things.
Right.
I'm like, I don't know. So I know, and actually we got this brief from the university. Companies are doing this, and everything that you put online. Let me give you another example here. Several years ago for Christmas, when the boys were younger, I was gonna buy them, iPods. Once again, dating me. My little kids want an iPod. You don't buy new electronics for little kids. You buy used stuff. So I on Facebook Marketplace or Craigslist or whatever, I find a few for sale. I'm like, send them an email. "Hey, wanna buy this? All right. Well, let's meet at such and such place." So all I do as the cautious type. We're going to meet in a public spot. And I was just like, I'm going to take that phone number and name and Google it. And literally in 2 seconds, the feedback I got was this particular individual. I found out that she works at one of the local restaurants. She's an Iowa State student, and she has a drinking problem. And the reason I say that is once again, she was arrested for OWI. And every social media post that came up, she was talking about going out drinking. Now, does she have a drinking problem? That's not diagnosable, but would it give an employer a pause if they did the exact same search? I bet it would. Yeah. And just know that. And is this fair, Dale? No. Right? Because
no.
Yeah, I mean, did such a thing exist? Right? We didn't even have Facebook.
No.
At least this guy could post stupid things on Facebook, right?
And we did.
And you did, because you were like, who's going to look at this, Exactly. But that didn't even exist back in our day, right? There was no social media. There was no, like the joke that from last time is like, did Brad Perkins go out to the Visha riots, and flip over cop cars? No, I was at home at the time, right? And you can't prove otherwise. Okay, I mean, did we go to Metallica concerts back in the day, or stay at home studying? There's no
get stuck in a snowdrift.
Or get stuck.
The second pass through.
Yeah, did somebody drive into snowdrifts in a 2-wheel-drive Jimmy back in the day that were taller than the truck? You can't prove Dale did that. It's only eyewitness, and his counselor here has established. That's a little sketchy for proof, and it's definitely not online.
It's not great, but I guess what are we learning here? Don't get arrested. That helps.
Yeah.
And then, I could speak from a litigation perspective. You'd be surprised. There are tools out there that you can learn more about somebody than you can with just Google. Okay, we all know that. I mean, it may not seem real to you, but just Googling and you're fine doesn't mean there isn't more out there. And then the second thing is that if 99 of 100 people listening, I don't know what the numbers are, but 99.9 people will never be in litigation, in any sort of lawsuit. But if you're the one, for whatever reason, discovery is very broad. I mean, you may have to give up your phone. You may have to download all of your private messages, and next thing you know, it's in a courtroom on a screen. I've had more than one case tank over the years due to social media, and whatever you want to put under that umbrella. You know, Facebook, Instagram are the old classics, but I know there are more. So, just what's the takeaway? One, be careful what you use your phone for. That seems obvious. And two, you got settings in that thing where you can set it to erase every 30, 60 days. Use it. Because some things can be erased, or at least get to the point they're very difficult to find. So that's not any specific legal advice for anybody. I'm not talking about evidence spoliation. However, use your tools that are available to you.
So let's say, there is a student or employee that's already gone down and they've, they have a record, or there's something on the internet that they can't erase.
Yep.
What would you suggest to them to kind of get past that point, or maybe rebuild a relationship with a future employer so that way they're not looked at in a negative light because of that?
Just as in-house counsel, I don't have much to do with hiring, so I'm going to defer to Dale. I can speak from my own life advice, which is how you're in a new world that I haven't experienced, so maybe I can't give the best advice, but even Baker Group, how did I get the job? Relationships. All right, so you can still make your way through this world by putting yourself out there, getting into organizations, meeting people, developing mentors, getting somebody who can vouch for you and overcome a past mistake. I mean, I'm guessing that it's pretty hard to get a job. It was in the past, and it probably still is, by just submitting resumes everywhere. Professor, what do you think?
Well,
I mean,
okay, maybe.
Maybe.
All right, now here. There is a lot of the problem that we have in the construction world is we have more work than people, and the demographics are against us. And by that, what I'm saying is there's not enough their age to replace all the people our age. I mean, that is just there's no other way of looking at it. There's too many, and that's true for management. That's true for everything. Plumbers, pipe fitters, electricians. It is just the facts. So with that in mind, companies are pretty aggressive about hiring in engineering and construction. I'm not, that's not every industry. That's
right. But
okay. For our listeners that are in construction engineering, that is true. However, what you said though is absolutely 100% correct. Relationships trump everything. Everything. It in both ways, both good and bad. If let's say Dale's like, hey Brad, so and so submitted a resume, and we kind of liked him when we talked to him at the career fair. What do you think about student X, right? And I'd be like, yeah. Yes, I will confirm that is a student at Iowa State University, and I suggest that you go to the office of the registrar to verify that they've met the requirements for graduation. Right. Dale's like, that's not the response I was looking at, right? What about this other guy, Dan? And I'm like, oh, Dan, let me tell you about Dan. I've known him since he was in high school, literally at DMAC, right? And I've known Dan, and he was my president of our MCA student chapter. And by the way, he was in all these classes, and we go on about going on MCA conventions together, and I can tell him about the scholarships that he's won at a national event. Which student is Dale going to be looking at? Right? Yeah. And nothing on their resume will outspeak that personal reference. Yeah. Nothing. Yeah. Not his GPA, not his resume, not his transcripts. Nothing will speak louder than. And this is something I find fascinating in an era where we are so focused on, my LinkedIn profile and my, like all the online stuff. Let's be honest, personal references still speak the loudest, and in some ways they dwarf all the online stuff. So I would agree with what you're saying completely.
Good. Okay.
Yeah, and I would also throw in if you have something on your record, the first goal is the purpose of your resume is to get an interview. So when you go to an interview, that's your opportunity to talk about it. I would bring it up If you think it's something of significance, I would bring it up.
I would agree.
And say, hey,
I'd agree.
if you guys end up doing searches on backgrounds and whatnot, the thing you should know about me is at some point in time you'll bump into this, and here's the explanation. Here's what I've done since then. Depending on what that thing was, and just bring that up yourself as opposed to them finding it out. It shows them that you're to a certain extent trustworthy, honest, and willing to be a little bit vulnerable during the interview process, and telling them something about you that maybe doesn't paint you entirely in a bright light, but it may feel like it's not painting you in a bright light, but it actually is if it's the right employer. And if they're looking for that type of employee that's going to be straight up and honest with them, and you can turn it into what might seem like a blemish on your record into something that they actually prefer you because you brought that up instead of trying to hide it. So that's what I would
agree
say
with that. Yeah,
about a situation like that, and relationships being the ultimate kind of the ultimate trump card. It's not that you have a relationship and you try and trick somebody into employing you, but you have a relationship. The foundation of a good relationship is trust. And so if you have a relationship with somebody that employer trusts, and that person is willing to speak up on your behalf, you can't be a dirtbag. Brad's not going to speak up on behalf of a dirtbag if I call him and ask him about a particular student. So you have to be trustworthy. You have to be a trustworthy individual, and having a relationship with somebody, and getting a connection. That's to a certain extent what makes the world go around. In a trustworthy environment, and you can know people, and it's not about having a relationship with somebody to sneak in the back door. There's nothing wrong with using that relationship to at least get connected, and then that's your opportunity to get an audience with them. And once you get an audience and you got a stage, then it's completely on you to go to that interview prepared, have questions, be inquisitive, and really they're doing speed dating. If you haven't done an internship with them, or that's their only knowledge of you is the resume, they're going to talk to somebody that's got the resume and a reference and a personal reference of somebody that they trust. In order to ultimately, the first step is to sell the interview and just to get across the table from them, and then it's 100% on you.
Yep.
So I hope that gives some insight into your question, Daniel. It's a good question.
I like the questions. Any construction law questions?
Yeah, let's give students a chance, because we got a little bit before our counselor has to leave. So let's get to it, all right, students?
Yeah, I've got a question. So say you really like a company and they are pushing you to sign like a non-compete. Is it possible to just tell them no? Say you really want to work for them, just try to get that off your contract, I suppose is what I'm asking.
Yes, that's the answer. Have the conversation. Always have a conversation.
Everything in business is negotiable.
Yes.
Everything. Is it possible? Yes. Will they do it? I don't know.
How much do they like you?
Yeah, how much do they like you?
Yeah,
You
and
know?
certain companies, depending on the role and what they're hiring for, have hey, anybody in this role, we're having them sign a non-compete. And if you say, hey, I don't want to sign this thing, then they'll say, okay, that's great. You can go to work, you just can't work here. And so some companies that is their stance, and you don't know that unless you ask. But I would at least ask, and have them explain, and then also understand what the limitations are, and then also know kind of the ace in the hole is you may sign that thing, but within 2 years that thing may not be enforceable anyway, or it might be. You have to, if you sign it, you have to assume it's going to be enforceable. So understanding what you're signing, and then if you ask them about it, and if they draw a hard line and say no, you have to. If you're going to come to work here, you have to sign that. Then that's your opportunity to say, hey, can we have an adjustment in the base pay? Because as you understand what that restriction is, then that's where you negotiate.
Is it worth
either
it?
the base pay or what is the limitation? Understanding it.
Exactly right. It's a dance. You just got to play, dance the dance, and eventually make a choice.
Are there any limitations to non-competes? So, say, I work at Baker Group for many years, and this is just an example, and I have a non-compete signed with them. If I decide to pick up and move over to the West Coast and work for a mechanical contractor of same size and scope,
You'll be fine.
Okay.
Yeah. So I don't mean to scare people with non-competes.
No. It's a very good thing to understand, though. Yeah.
Yeah.
We want
it's
to
really-
scare you into reading them.
It's
And-
more
but
of
they're
a,
not scary documents, but we do want to scare you into reading them.
Yes, that's right. And Dale's also right that just because you sign one doesn't mean that the company you're leaving will choose to enforce it. If you're a good employee there and you've put good work in and they like you, I've seen it like, you know what, we had you sign that. It was kind of a business practice. We're being protective. We wish you luck. You know, I've had that conversation with people outside of Baker Group, and that's where you put good work in, and you can build that capital with the employer. But to answer your specific question, they have to be very limited. Okay, so the courts don't like them because they're not good for workers. There's a very strong argument that they suppress wages, right? Suppress competition. They put some sort of handcuffs on you to keep you at your job, which is not necessarily good for the labor force. So courts will, if someone had, I've seen them where they say you can't go work anywhere in the country. The courts, if you were to take it to them and ask for a declaration it's unenforceable, they'll write it down to 200 miles around your employer, something to that effect. It's called blue penciling in the law. They'll blue pencil the agreements.
Write that one.
I did not know that one. I had not heard this particular
Yes.
term.
Yeah.
So also you talked earlier about how you encourage people to come to you earlier with their legal troubles, you would say. So how would you go about dealing with somebody that maybe didn't do that and it's gotten to that stage where it's a big problem now?
I'll just
After he does the hand slap,
I'll just
then
beat them, punch them,
Beat 'em.
insult them.
The first offense is an open fist. The second offense is a closed fist.
Dale knows that. He's on strike 3. No. The one thing I hope people understand that at least I work with is, look, we're on the same team. Okay. I might roll my eyes and say, hey, man, why didn't you ask me about this sooner? But no big deal. I'm on your team now. Let's do what we can. Okay. And then I might say, in the future, if you could please do this, you're going to really help yourself. But you guys back me up on this. Sooner's better, but even later is better than just trying to ignore it and hoping it goes away, whatever that problem might be.
Ooh, that sounds almost like advice I give people on groups.
Ah.
Right. That just pretending it doesn't exist is a lot like driving a truck that's making a noise, right? Just ignoring it and turning up the radio does not really fix things, and it will probably just get worse, not better.
That's right. Yeah.
Okay. And that's good advice for pretty much any problem.
Yeah. That construction company outside of the construction company life.
Yeah.
So, yeah.
Yeah, and the thing that's made us stronger with Blake being in-house now is we didn't have anybody that we could go down the hallway and say, hey, I'm in a bind. It was, okay, we got to call up outside counsel, and it's $350 an hour. So we were pretty resistant to do that just because of the time commitment and the financial commitment. But having him in-house has really helped our organizations and our organization and our project managers get better at their job because he's available. And he's on the same team, and we're really trying to not fight the same battle in the sense of trying to beat somebody, but just making sure we understand what the limitations are and the risk, being able to quantify it.
I think that's maybe not everybody, in-house counsel, legal department. We got a battle.
We got 10 minutes.
No. Yeah. So whenever you guys want to shut me down, I'm okay.
Yeah.
I was just going to say, I'm trying to, I think most in-house counsel would say, at least I do, bring anything to me. I looked at a non-disclosure agreement for somebody. Hey, they're asking me to sign this. You got 2 minutes to look at this. Anything in there that I should be concerned about? No, it's good. Go ahead. It could be simple. It could be big. And by big, I mean, we got a huge, some roof drain leaked, and now we got $1 million in damage. It could be big, small, just a resource. I want to be a resource in-house. So any sort of document, it doesn't have to be like a legal thing. Contracts, documents, submittals, all of that stuff I deal with on a day-to-day basis. So
Something I haven't mentioned yet, non-disclosure agreement. So if you are working for a general contractor and you're building a building for a client that doesn't want anyone to know that you're building that building for them, data centers are a really big thing right now.
Yeah.
It's like Fight Club. You don't talk about Fight Club.
Yeah.
Number
You don't
one
talk
rule.
about
You don't talk about data centers. You don't run around. You don't get hey, just got my first job out of college. I'm project manager for company XYZ. I'm working on such and such data center. I'm going to post a bunch of pictures. You'll get yourself removed from that job site very quickly and possibly from that employer. And it causes all sorts of pain for your employer and all sorts of pain for that data center owner. So if you're signing a non-disclosure, if you don't have, and a lot of them are several pages long and they're a bunch of legalese. And if you don't understand everything and you just sign, just assume you can't say anything to anyone about anything. And so especially with data centers that are being built right now, that's a super hot button. So pay close attention to that. You can get yourself fired faster than you even know what's going on.
I got a question for the students. You guys all take, is it 380s, the law class?
Yeah, that's one option. There's a couple of other classes that they could take as tech electives, but 380 is one of them.
Did you guys take 380? Anybody?
I did.
Yeah?
I took Brad's class in the winter, a couple winters ago. So.
Well, I'm just curious, like, what are the topics? Like, what stood out to you? What do you remember? What was tricky, didn't make sense? Well, don't say that because the professors, right?
He already passed it.
Okay. It all made sense. It was great.
I know we spent quite a bit of time. I do remember the station fire and the litigation surrounding that after it happened. That was like one of the main things I remember. Torts, liens. It's been a couple years, so I'm not gonna pretend like I remember everything. But
how about flow down provisions? No,
I don't think we talked about that.
I mean, maybe that's a subcontractor deal that I'm stuck with constantly. But and that's one. If you go to work for a trade or a subcontractor, we gotta learn that one. That your subcontractor is not the only contract. Like you're beholden to everything upstream as well. So. I'm just curious about this class. I kind of wish I would have taken it.
You know what? You still can.
Yeah.
Right? Yeah.
Can you
get
still
in.
like audit classes in college?
Yeah.
You can. You can like show up and just be like, hey, I'm.
Well, now this class is online, so it'd be hard to audit.
Oh, okay.
But let me think here. Yeah, I think you could take. You can take up to 3 classes without actually being in a major. All right. So so you probably could take it.
That's
If you wanted to. All right. Anyway, and my class right now is just online.
Yeah.
So you'd have to watch it online, which is probably what you'd want to do anyway.
Do you focus on like the designers or like constructors or both?
Both.
Both.
Yeah. There's a good healthy amount of both.
Yeah.
There's a lot of focus on construction and law, but there's also a lot of talk about engineering and law.
Yeah.
Because we get a lot of students that aren't necessarily construction engineers. There's the traditional mechanical and electrical and industrial and civil and so it's just really supposed to be not to turn you into a lawyer, but turn you into a good consumer of law.
Sure. Yeah. That makes sense.
That's the point.
What about you three? If not to monopolize the conversation here, but like, where are you guys aiming for when you get out of school? Are you aiming to be construction project managers, engineers? I'm just curious.
I guess I'm looking to get into management. It's kind of all I've known so far. I'm in scheduling and estimating right now, so I'm kind of getting the feel of those and kind of getting a feel of the options that I have. But as of right now, I've really enjoyed doing my internships in project management.
Gotcha.
Project management as well. I'm definitely gonna take my FE and maybe look into design later on. But again, I interned at Baker Group for parts of 3 years.
Recently?
Recently, yeah.
Like this past summer?
Not this past summer. My last summer was 2023. Oh,
okay. So I just missed you.
Yeah.
Gotcha.
But I mean, all I've known is project management as well.
Gotcha.
But I'm definitely interested in some of the design parts.
Yeah.
So
Yeah.
kind of split on that. I'm thinking about maybe making that change later on, depending on how things go with project management.
Cool.
So
Yeah, I'd say for me right now, I'm not completely sure. I'm just a sophomore. I've been through one internship, and I'm still trying to like branch out and see what experiences I get at different places. So
Yeah,
kind of go off
yeah.
that.
Yeah. I wish law school had done a little bit more of the intern. So we have this concept called clerking, where you basically an intern at a firm. But I wish there was more like a rotation to it, like go work for a criminal defense firm, go work for the prosecutor's office, go work for civil litigation, go work for a construction company in-house. Like construction law wasn't even a thing that got discussed. So I wish there was more exposure. Yeah, that's a good idea to expose yourself.
Yep. We definitely recommend, and most, I'd have to say probably 90% of our students have internship experience by the time they graduate. For construction engineers, not all Iowa State students, but for Connie, we heavily recommend internships, and most of our students get a good internship before they graduate.
Yeah.
you get some weird looks if you don't have you get some weird looks if you don't have an internship by the time you've graduated.
Okay.
That's funny because literally just today on my LinkedIn, someone that was at the career fair yesterday sent me this email. They're like, hey, the student applied and we really liked him, but he doesn't have an internship. This is kind of weird. You know, and I think he had some things going on with sports and traveling and that type of thing.
Yeah.
You know, but it's like, well, ask him why not, you know, because that's a choice. But, you know, sometimes you get students that are in the military and they're doing stuff in summer and you can't really get a good internship.
Yeah.
Sometimes some of the sports teams are traveling and they can't do internships, and there's all the different laws on how you pay them and stuff like that.
Right.
But,
Right.
all right. Well, hey, I was getting the 10-minute warning here about 5 or 10 minutes ago. So we're going to pause things here. I just want to thank you guys from Baker Group for coming and for bringing me a sweatshirt. I will be wearing this in class. And I want to thank students for taking time out of their day and coming over. I appreciate that. I know you had to get out of class and get here, so I sure appreciate it. It's always better with students being able to answer some questions, and that's really what the podcast is all about. So we're gonna stop here and thank everybody for attending and everybody for listening.